Talking about the appointment of a small shareholder director, section 151 of the company's appointment qualification of director rules 2014. A listed company may, upon the notice of 1000 shareholders or 1/10 of such shareholders, which are small shareholders, lower of the above, have a small shareholder director elected by the small shareholder. Such director shall be considered as an independent director under section 149 and giving his declaration of his independence. Reference, the video has already been uploaded for section 149. Please look into it. Talking about the small shareholder is the shareholder who is having the shares of the nominal value not more than 20,000 rupees or such sum as may be prescribed. A person appointed as a small shareholder director shall vacate the office if he is disqualified under 164, disqualification of director. Office vacates under section 167 if he fails to meet the criteria of independence under section 149. Talking about the small shareholder who is intending to propose a person as a candidate for the post of small shareholder director shall leave a notice of his intention with the company at least 14 days before the meeting under their signature, specifying the name, address, shares held, folio number of the person whose name is proposed to be director. This is whose. If a person do not hold any shares, then the detail need not to be given with respect to the shares or the folio numbers. So that means if you're not holding the shares of a company, you can still go ahead and become the small shareholder director. Talking about the listed company who opt to have this suo motu, I mean, if in the scenario where the small shareholder director has been the charge has been taken up by the company of their own and the company is listed, then they do not need to comply with the provision mentioned here. I mean that they do not need to comply with the provision discussed in this aspect. The notice shall be accompanied by a statement signed by the person proposed to be the director, stating that then not disqualified to become a director, his consent to act as a director, that is DIR 2. The person shall be appointed not be appointed at small shareholder director if he is not eligible for appointment under 164. This is disqualification of director. The appointment of SSD shall be subject to the provision of section 152 except that he shall not be retired by rotation, tenure shall not exceed 3 consecutive years. On the expiry of tenure, he shall not be eligible for reappointment, and no person shall hold the position of small shareholder director in more than 2 companies at the same time. However, the second company in which he has been appointed as a small shareholder director, the business shall not conflict with the business of the first company. So that's a mandatory. Moreover, on the expiry of first term of 3 years, the cool down period is for 3 years further. So this was a small shareholder director. Thank you.